Hello, I am Anthony Winton, a researcher at the Bingham Center for the Rule of Law, and I am really pleased to have the renowned international criminal lawyer, Arthur Traldi, joining me on the line. Hello, Arthur.
Hi, Anthony. It's an honor to be here and to speak again with folks from the Bingham Center.
Thank you. And where are you joining us from today?
Easton, Pennsylvania in the United States.
Tremendous. Well, thank you very much indeed once again for agreeing to share your insights with our students. I'm most familiar with your work from the excellent documentary, The Trial of Ratko Mladic. And I know from that you worked for a number of years at the International Criminal Tribunal for the former Yugoslavia. So to begin with, could you tell us a bit more about your work there, please, and the other institutions you've worked with?
Sure. I've worked over the years at ICTY as well as the International Criminal Tribunal for Rwanda, the War Crimes Chamber of the State Court of Bosnia and Herzegovina, and my state courts here in Pennsylvania. I spent 8 years, about half my career to this point, as a prosecutor at ICTY, mostly on the cases against Ratko Mladic, who you mentioned, and Vojislav Šešelj. On Mladic, which was my primary work for about 5.5 years, I led the team responsible for prosecuting the part of the case that referred to allegations of mass atrocities in 14 municipalities, including about 40 massacres, crimes in 40 different detention facilities, and the expulsion of hundreds of thousands of people from their homes. That meant examining witnesses regularly and working as part of a team of great lawyers, investigators, analysts, interns, and particularly trial support staff to make the case work.
Well, Arthur, that's incredible. We're hoping that our Rule of Law course is really going to inspire people to become engaged citizens who can be vigilant in defending the rule of law. And I have to say, you serve as a great role model for us all. Now, it occurs to me that the sort of cases you have dealt with in your career provide some of the clearest illustrations of what can happen when the rule of law breaks down in a society. I'm wondering if, in your experience, you've identified common elements that lead to these atrocity situations, and more particularly, are there common rule of law failings? I'm thinking of structural weaknesses in the checks and balances, such as insufficient separation of powers or the lack of an independent judiciary.
Yeah, I think the biggest thing, and maybe this is a less direct rule of law relationship, is seeing people start viewing each other as part of different communities competing for control rather than as part of the same community. And whether that's seeing each other as Hutu or Tutsi instead of Rwandan, or as Serb, Croat, or Muslim instead of Bosnian, or through the lens of ethnic difference anywhere in the world. And it's tricky to think through because, of course, groups have collective interests and collective needs and rights for self-determination. But within a specific polity, when we start seeing each other through a lens of grievance rather than as neighbors, I think there's a risk that things start to break down. Sometimes it's a symptom of a failure to properly address past issues. Sometimes it's a result of propagandizing by folks seeking power, and sometimes it's been going on long enough that we can't immediately get around it and just have to manage it. But when we see and hear that somewhere, it should be a warning sign, I think, that we ought to keep a pretty close eye on what's happening. In terms of more basic rule of law conditions, I think you look out for institutional capture, and that always means an erosion of checks and balances, and it's possible in any institution, domestically or internationally. In the US, we learn in law school that we have a government of laws, not men, as they say it. And one of the things that tells us, of course, is some of our sayings come from a time when there weren't any women in government. But the other important thing it tells us, aside from the fact that we've moved forward in important ways, is that power is expected to be exercised within a clear grant of authority. You know, there are areas where you can't anticipate every issue, and so a measure of discretion is both necessary and appropriate. But I think there's real value in the sense that what you do with power, and particularly what you impose on others through state authority, you have to be allowed to do through a clear law. And when that sense is lost, I think it opens the door for for taking measures that aren't lawfully granted and taking measures that target specific people or specific groups.
Yes, absolutely. And leading on from that, and as part of that really, turning to your mission, your vocation, if you will, as an international criminal lawyer, why is it that you believe that international criminal law and combating impunity is so important? Or phrasing it in a more rule of law way, why is it so important that nobody, including the most senior political leader, is above the law?
So I think about proper litigation of international crimes, and by those I mean the sort of mass atrocities that I've mostly worked on, first and foremost as being about the fact that certain types of crimes just call out for justice. When you talk about body counts in the thousands or the tens of thousands, or in Rwanda, the hundreds of thousands, as a result of crimes clearly precluded by law, it's not a philosophical question. I think, first and foremost, for most people who work in the field, it's emotional. The people who suffered that way deserve a remedy. But putting in a rule of law way, I think the value for it in a rule of law sense is a fundamental point about equality. The law is the law and it applies to everyone equally. And that means it's a fundamental point that nobody should be above the law, and that even in cases involving very serious allegations against very senior political leaders have to be prosecuted at the same level in terms of satisfying our burden of proof, respecting due process rights, and adhering to jurisdictional limitations as you'd expect in any domestic criminal case. And I've been proud that I worked on teams that took our responsibilities as prosecutors seriously and understood we too were bound by the rule of law.
Tremendous. Excellent. Thank you, Arthur. And my next question is that most of our course has focused on the domestic rule of law. That is, how the rule of law operates within a state. But of course, we are also living in a very troubling time for the rule of law on the international level. In many countries, we are seeing increasingly powerful political actors calling for increased disengagement from international law and institutions, including threats to withdraw from the jurisdiction of international courts. And that has included, of course, the International Criminal Court. So focusing on your area of international criminal law, is there anything that you identify as specifically causing resentment towards international criminal law, or a lack of trust in institutions such as the ICC? And what do you think can be done to remedy that, to reinforce the international rule of law and its institutions?
So one thing I think is fundamental here is that countries are just different than people. Sovereignty is a huge concept, and it's what says that the United States and United Kingdom and Cambodia and Liberia are supposed to interact, whatever their power dynamics, as legal equals. And that means they essentially have the obligations to each other that they agree to have. So international rule of law has to have that aspect of recognizing specifically sovereign equality that domestic rule of law doesn't. And it's a big difference, I think. The ICC obviously was come up with by folks who aspire to its universality. I think that's probably pretty common among people who work there. But you can see that it recognizes it's not universal. And for instance, one of its recent decisions extending its jurisdiction. In the Myanmar and Bangladesh decision, the court found it had jurisdiction over displacement from Myanmar into Bangladesh because the crime wasn't completed until part of it took place in Bangladesh, because you had to cross the border. But nobody suggested that murders or rapes that were solely committed in Myanmar would be within the court's jurisdiction to prosecute, because it recognizes that the rule of law means it's bound by its limitations, and those include the jurisdictional limitations set out in the statute. So I think some of the criticism of the court comes from folks that are concerned about how it extends its jurisdiction into situations that maybe weren't directly the sort that were initially expected when the Rome Statute was put into effect. But some also comes from folks who don't understand that the way it is a court of laws rather than just people is that it has limitations that are based on traditional principles of international rule of law, and that it can't be expected to do everything unless every country signs up to it. But the other thing I think in terms of trust, I think there are two other things to say that are important, both in fairness to the court and in fairness to some of its critics. And the first is, in fairness to the court, that there are powerful folks who have an incentive, because they become suspects in investigations, to target the court for criticism and for allegations of bias. And for instance, when the court is criticized for focusing on African cases, of course, there are two ways of looking at that, right? The first is that African victims are getting more attention, and the second is that African defendants are getting more attention. And you hear the second interpretation a lot because a lot of the potential defendants have a little bit more access to press and to the international diplomatic sphere than potential victims do. But the other thing to say, I think, in fairness to some of the critics of the court, is one of the things you'd expect an institution that wanted people to expend political capital to support it to do would be to show some results, put some points on the board. And ICC hasn't done a lot of that. I think right now there hasn't been a conviction upheld on appeal for something like half a decade. And that's hard. That makes it hard to expect folks to make diplomatic or political sacrifices to help the court fulfill its mission when it doesn't seem to be doing that at the moment.
Yes, indeed. And of course, you always have to have an eye on maintaining those rule of law, fair trial standards as well, of course.
Of course.
Now, my next question relates to much of the discussion in our rule of law course concerns the contrast between thin and thick conceptions of the rule of law. And as my colleague Michael Olotoken explains in week 3 of the course, equality before the law is a cornerstone of the rule of law. However, under a thick conception of the rule of law, it is sometimes necessary for the law to treat people differently in order to reach a just and equal outcome in practice. And Michael gives the example of how the criminal law would treat a child differently to an adult. This immediately brought to my mind the highly contentious issue in international criminal law of the culpability of child soldiers, and how does the rule of law grapple with issues of guilt and innocence in such a context? For example, are people who are, let's say, abducted as children and brainwashed or press-ganged into combat to be treated the same as other defendants? Some would argue that they should be convicted but have their circumstances act as mitigation during sentencing. Others would say that they are victims even if they continue to commit crimes as adults over the age of criminal responsibility. So I'm just wondering, what is your take on this?
So I haven't worked on child soldiers cases myself, though there's a fascinating case at ICC right now, Ongwen, dealing with exactly these issues.
Yes.
I think here's a good example of where I think one of the things that maybe a thick conception means, and this is a pretty traditional articulation of it, is treating people as an individual with due regard to their own circumstances. I think it's particularly important in a case like what you're talking about to have good evidence of what somebody went through themselves and how it affected them before the court, because you're going to have pretty strong pulls in a couple of different directions, right? Somebody will wind up in a trial like this. A prosecutor will, you would hope, exercise discretion to indict only if somebody is charged with and credibly accused of very serious crimes. And you would think, in most cases, at least childhood trauma would serve as mitigation. But you'd need a real thorough, individualized inquiry, if that's what the case is about, into how it affected them from examining psychiatrists and the sort of real individual inquiry that I think we see more often in domestic courts. More generally, I think it's a good reminder that we could all use more empathy for everyone who comes before us in my field. That most people, both alleged victims and alleged perpetrators who are part of these cases, may have gone through things that many of the lawyers on the cases couldn't imagine. And how we fairly figure those things into a legal analysis is a question that I don't think we have an answer to yet, but it's an important one. And Child Soldiers gives us a really useful window for trying to think through it in a rigorous way.
Definitely. And finally, you currently do a lot of work on rule of law capacity building. Could you explain what that involves, please? And do you see that work as having a tangible impact on helping those societies you work with to reconcile and move forward? In other words, does strengthening the rule of law help to stabilize a fragile state?
Yeah, I think really strengthening it certainly does. And rule of law and capacity building, of course, are both terms that lots of people use in different ways. But typically what I do is help locals, whether it's non-governmental organizations or prosecutors, do their jobs rather than trying to have somebody from the outside do it. And sometimes that involves working with them on best practices or conducting an assessment to see what an organization or a prosecutor's office needs. And I typically learn a lot from it myself, of course, but it's a small part of the process. And in the end, ownership of reconciliation has to be with locals and their communities. And I think a little bit about ICTY, of course, in this context, both because it's such a big part of my career and because it's such a strong example of how our thinking about this, I think, as practitioners has evolved. There were certainly large-scale references in the initial documents establishing the court, initial United Nations discussions about it, and other international conversations about the role that the court would play in reconciling societies in the former Yugoslavia that had been through so much trauma. And when we had legacy conferences in 2017, one of the things that I most remember the then president of the court, a Maltese judge named Carmelagis, saying is, we brought truth, not reconciliation. And essentially, I'm going to paraphrase the next sentence or two, but what he was saying was, reconciliation's your job. It's not something that can be imposed from outside.
Yes.
And so there are some benefits, I think, to doing these cases right, to having a fair process that can be trusted. and to making clear that responsibility is being allocated individually rather than collectively. I think those things help with reconciliation and moving on. But it's always a balance. There are downsides to having such cases litigated 25 or 30 years after the fact, and it's a society-specific question, I think, whether it is helpful. But all of those impacts that folks on the outside can have or can fail to have, they're very small compared to the role of people in a society. And the fact every Bosnian leader, for instance, who didn't push to secede if they led the Republika Srpska or led the Croat community, when high-profile defendants on their side were arrested, were called on their supporters to keep calm and tamp down any risks of violence when high-profile arrests or judgments came out, did, I think, more for reconciliation than a trial did. We can help create conditions, but there's a real limit, I think, to what we can do as outsiders to reconcile.
Yes. Well, Arthur, you have given us an awful lot to think about there. And thank you very much indeed again. And I wish you the best of luck with all that you're doing. And as I say, you're a great inspiration to us all. And please keep up the good work.
You're far too kind. Thanks very much, Anthony. It's been a real pleasure talking to you, and keep up the good work yourself.
Thank you, Arthur. Bye-bye.